Hello, everybody. Today's lecture is going to be about ethical considerations for legal assistance. Now, okay, what does this mean? Well, basically, it boils down to look, if it feels wrong, don't do it. That's the very basics of this. So we're going to go through a number of slides here and we're going to have a discussion about, really what are the ethical parameters for legal assistance? Does the same thing that a lawyer has to abide by as far as the ethical rules are concerned? Does the legal assistant also have to abide by that? The other people in the office? I mean, what's going on with this? So let's find out. Okay, so first of all, what is ethics and where does it come from as far as, what rules do you have to abide by? Well, there's the definition for you right on the screen. Ethics are those standards by which conduct is measured. Most ethics rules seek to enhance the integrity of a profession by establishing the minimum level of conduct required of its members. Now think about that. The ethics rules are establishing the minimum level of conduct. That's the bare minimum, literally, that you can do. That's what these rules are. Obviously, you can have higher ethical standards and behave in a more ethical way than what the rules require. So first you have to figure out, okay, what are the rules? And I know that's the minimum. So hopefully all of you will choose to go above and beyond what the rules require and hold yourself out to be the most ethical that you possibly can. However, you want to make sure that you know what the minimum level is, because some people, they think that they're doing the right thing, but they really aren't. So where do the questions come from on the CP exam? That's what we really need to be concerned about, because all of you are studying for the certified paralegal exam. They're based on the ABA, that's the American Bar Association, their model rules of professional conduct, and then the NALA, which is the test, the certification body. What their code of ethics and professional responsibility are for legal assistance paralegal. Both of those are available to you in your book. You can also look those up online. Okay, so what are the main objective for legal assistance? Well, what do you need to know? Well, I want you to think about these two things, because every time you are faced with an ethical dilemma, or if you are faced with a question in the ethics portion of the certified paralegal exam, you want to always remember these two things. Number one, if I take this course of action, is that me maintaining my highest level of competence? That's the first objective. Am I maintaining my highest level of competence? If the answer to that question is no, you're not maintaining your highest level of competence, then you're not doing something that's ethical, and you're going to miss that question on the certified paralegal exam. The second thing you want to consider, okay, I'm maintaining my highest level of competence, but am I going to be committing the unauthorized practice of law? Those are the two main objectives in the legal profession for legal assistants and paralegals. So, are you being competent, or are you practicing the unauthorized practice of law? If you're doing either of those things, it's unethical behavior. So, what is competence? Well, that means you have the ability, the capability, the expertise, and the mastery or proficiency or skill to do the job for which you have been hired to do. You have got to have sufficient knowledge, training, and skill to do the job. That is assumed. Every client that comes into that law firm is making the assumption, as is the legal profession, that everybody in that office, from the lawyer to the paralegal, the legal assistant, to the secretary, to every person in that office, they are assuming that you have the competence to do that job. Now, it's a little bit of a high standard, because you can't just have anybody off of the street working in a law office who doesn't understand what they're doing. If you have that person in your office, it's a liability for everyone. Unreasonable procrastination is unethical. Okay, that's the number one complaint that clients have about attorneys. They never call me back. They take 2 weeks to call me back. They didn't file this thing on time. So if an attorney or a law firm is going to get in trouble, it's going to be because one of the reasons, and one of the main reasons, is because they're just not doing things in a timely fashion. So do not procrastinate. As a legal assistant or paralegal, it is your job Number one, to make sure that you are competent, that you understand your job. Number two, that you are doing things in a timely manner. And if you work for an attorney who tends to procrastinate, it is your job to get their butt moving every day and to get things filed and to make those phone calls. And if they're not making the phone calls, you make them because you are the face of that law firm. You are representing that attorney and you can save their butt. And when you save your attorney's butt, guess whose butt you're also saving? Your own. Because if your attorney doesn't have a job, you don't have one either. Okay, so what are some things that you can do to make sure that the law firm that you are working for is maintaining that minimum level of ethical conduct? Questions that come up. Does the law firm that you work for, do they do any advertising? And the answer to that question is probably yes. Every law firm does some advertising. And then what is this solicitation? We got to figure out what that means. That always sounds like something from your criminal law course, right? Let's look at advertising. What type of advertising can the law firm use? What can they do? Well, they are permitted to advertise, obviously. And the ABA model rules do not prohibit what information a lawyer can give about himself or herself during the advertised processing. It doesn't even limit this, what we consider undignified advertising. That's where the attorney's wearing a clown suit or jumping up and down. Hey, hire lawyer Larry. Burr, 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 burr. Okay, I know that sounds like a crazy person, right? And that would be undignified. However, the American Bar Association model rules do not prohibit that type of conduct. So if you see some kind of crazy question on the certified paralegal exam where, oh, well, the attorney's dressed up in a clown suit, well, you're going to think to yourself, boy, that doesn't seem right. Unfortunately, it's not prohibited. Now, a lot of individual states, which you will not be tested on, they have rules against the undignified advertising. But for your studying for this test, you need to focus on the fact that no, the ABA doesn't prohibit that. Now, what are some things that are unethical for attorneys to do when it comes to advertising? Well, it's unethical for lawyers to pay referral fees, except in the case of a nonprofit referral service. So what does that mean? Well, you can't say to your client that you already have, Mary Smith, okay, Mary, if you bring in, for every person you bring in, I'll take $500 off your bill. That's a referral fee because they've brought in new clients. You can't do that. Lawyers can't do that. That's unethical behavior. So that is not the way that you were supposed to get clients. Now, the exception to that rule is if that the lawyer is paying referral fees when it's a nonprofit referral service. Sometimes they have these referral services that refer clients, a client, I don't know what lawyer I need, so they contact this referral service who has a list of attorneys who perform certain basic services, and then they will give that client, that potential client, a list of attorneys that they can call that do that type of law. An attorney can pay to be a part of that type of a service because again, there's a third party involved. You're not paying some client of yours. You're not paying. This is an actual company, a nonprofit company that is set up to provide assistance to people who are looking for legal help. Okay, so hopefully that's all clear. What about solicitation? This is that whenever you think about ambulance chasing, that's what solicitation is. You cannot, anybody who works for the law firm and the lawyer, so all of these rules apply equally to the paralegal and the legal assistant as they do to the lawyer. You cannot go to an accident and start saying, well, gee, it looks like you really need a lawyer. I mean, look, you got run over by that guy over there and you really need a lawyer and I'm the lawyer for you. That's unethical. That is soliciting, a client who clearly is in need of legal help. And you're saying, I'm going to be here first. You can't do that. Okay. Now, if you already had a professional relationship with that person and you happen to be driving down the street and you see them there, they're laying on the road waiting for the ambulance to come, you can get out. If you had had a prior professional relationship, A, you want to see if they're okay. B, you can say, my goodness, it looks like you've gotten yourself into a situation here. That is okay. That contact is okay. Probably if you want to go above and beyond, like I said before, those ethical rules, you don't want to say, oh, by the way, I'll represent you if you need me to. You want to go above and beyond. You want to let them bring that up first before you do. Now, what is it that you can do? So how do you get clients? I mean, if you're an attorney and you can't tell people who clearly need legal services that they should hire you, well, you are allowed to send out a brochure or a letter to names found on an accident report. Okay, you can send it out to anybody that you think might need legal services, but you have to include advertising material, the words advertising material, and that needs to be on the outside of the envelope before they even open it up. And to go above and beyond the rules, you should probably put advertising material as many places as you possibly can, because you're targeting a specific audience, people that you know need legal help. You want to make sure that they're aware that it's advertising material and that you're leaving it up to them whether or not that they want to respond. Okay? All right, candor and honesty. Now, a lot of people think that people in the legal profession are just born liars. Well, that is not true. It is highly unethical for a lawyer to make a false statement of material fact in court. You cannot knowingly offer false evidence. You can't fail to disclose material facts to the court when you know that your client is going to be committing fraud or some other criminal act. So, lawyers, legal professionals are all held to the utmost of candor and honesty. So if you face any questions on the certified paralegal exam where it looks like the attorney is going to tell a little white lie or somebody in the law firm is going to tell a little white lie, no, you can't. It's absolutely unethical. That would not be the correct behavior. All right, communication with clients. The lawyer, and this includes the law firm also, needs to keep a client reasonably informed about the status of their case. They must comply with the client's reasonable request for information, and they must explain things to the client so that the client can make an informed decision. This all makes sense. So there may be some questions on the ethics section, which kind of are trying to see how much you know about this. Communication with the opposing party. This is where I think you're going to get the questions, right? A lawyer cannot have any contact with the opposing party about a pending case unless the party's counsel agrees to the contact in advance, which rarely will happen. So let's look at this scenario, okay? I represent Mary Smith, okay? Mary Smith is suing John Smith. Well, John Smith has an attorney. I cannot, as the legal representative of Mary Smith, I cannot contact John. I have to contact John's attorney if I want to give any communication in that direction. The only time I can talk to John is if John's attorney says it's okay. That almost never happens. Okay, what if John doesn't have an attorney? Well, then I have to talk to John. He's representing himself. He's acting as his own attorney. So just like I could talk to his attorney, now I can talk to him. But anytime there is a situation where a client is represented by counsel, the only communication that can happen with the other counsel. Well, what if John has counsel, we know he has counsel, and then John calls the law office and wants to talk to us? Well, we have to stop him. We have to say, Mr. Smith, I thank you for calling our office today. However, we are not permitted to speak with you. We must speak with your attorney. Oh, well, my attorney's not calling me back, so I thought I'd just call you directly. Well, I'm very sorry that he's not calling you back. We can contact him and ask him to please contact you and to return your phone calls. But we really have to tell you that we cannot talk to you. You have to cut that conversation off as quickly as possible, because otherwise he can come back and he can say that we did something unethical. All right, confidentiality. You guys all know you're not allowed to say anything that happens in the law office. It's kind of like Las Vegas. What happens in the law office stays in the law office. And as much as you want to, you cannot go home and tell your boyfriend or your girlfriend, hey, guess what happened in the law office today? You have to learn to keep it to yourself. It's going to be so exciting and fascinating, trust me, when you go work at a law office, and there's going to be so tempting to talk about it. if you're going to talk about it at all, you've got to change names, dates, locations so that nobody can figure out who you're talking about. So, this is the basic tenet of the lawyer-client relationship, is that what they say is going to be held in the utmost confidence. Now, there are some exceptions to this rule. If you think that the client is about to commit a crime or is going to kill themselves or hurt somebody else, then it's absolutely okay to contact law enforcement or whoever needs to be contacted in order to avert this situation. But you have to be darn sure that this person is going to commit a criminal act that is going to hurt other people or themselves, or they are going to commit suicide or something before you make that phone call. You've got to be very sure. Okay. Also, if the lawyer is being charged criminally, or if the lawyer has been sued by the client, then obviously you should be able to, the lawyer has a right to defend him or herself, so they can use information that they gained through the attorney-client relationship in order to defend themselves against any accusations made by that particular client. Okay, conflict of interest. Okay, a lawyer cannot represent opposing parties in a legal matter. I cannot and will not. If two people come into my office and they say to me, "We want you to do our divorce," and first thing I'm going to say is, "I will represent one of you, but I can't represent both of you." "Oh, but it's going to be an amicable divorce." Now, a lot of people think that. But then once you start getting into the nitty gritty, then it becomes he said, she said, and they're pushing and they're shoving, and this one wants the toaster, and this one thought it was going to be okay to have the family photos, and then it becomes conflict. And if the attorney represents both parties, how can the attorney represent one of those parties to the best of his or her ability and represent that person zealously when they also have to do the same thing for the party that is directly against them? It doesn't make any sense. The other conflict of interest is where I've already represented Mary Smith. Okay, I represent her. 10 years goes by. Somebody comes in, they tell me, "I'm going to sue that Mary Smith." I'm like, whoa, whoa, whoa. I can't represent you if you are going to ask me to do something that's adverse to somebody that I'm already loyal to. Mary Smith, I represented her 10 years ago. I'm already very loyal to her. You cannot ask me to now go against her because she trusted me with all of that information that she gave me 10 years ago. And you know what? If I represent you against her now, I'm going to have an inside and I'm going to know all of her secrets. Okay, that's why we have that rule, because people need to feel comfortable telling you their secrets. They don't want them used against them later in the future. Okay, so you can't represent somebody who has an adverse interest to one of your current or former clients. You can't represent two people in the same action that are against each other. Okay, now there are some exceptions to this rule. A lawyer can represent opposing parties if the lawyer reasonably believes that the representation will not affect either party adversely. This sometimes in a real estate situation where you've got a buyer and a seller. I mean, technically they have opposing interests because, the buyer wants, to buy the property for as cheap as possible. The seller wants to get the best possible price out of the buyer. So there's some conflict there. But sometimes there's not a conflict. Maybe it's a transfer of property between family, and there's not an issue about price or anything like that. But both parties have to consent to that. Okay, so it can happen sometimes, but not often. All right, fraud, criminal conduct, and fees. Okay, obviously the law firm cannot advise a client to commit fraud or to do anything that is against the law. Okay, that's the basic of that. I can't recommend that somebody go out, "Oh, well, the best thing for you to do, sir, is to go shoot that person in the head." I mean, that would just be absolutely ridiculous. You cannot give that kind of advice. And then fees. A lawyer's fee must be reasonable. Now, the whole planet thinks that lawyers charge too much. But once you start working in a law firm and you understand the complexity of these cases and the liability that the attorney takes upon himself and his firm, for all of the things that they do. I mean, potentially, these are multi-million-dollar situations sometimes. And, so it becomes worth that hourly rate. Now, contingency fees cannot be used in criminal cases or divorce cases. And you've been through so many legal classes at this point. You understand that contingency fees are, we don't get paid unless we get money for you. That's where, the attorney upfronts all of the costs, and then they take maybe a third of whatever they're able to get for their client. So that's what a contingency fee. You can't do that in a criminal case, and you can't do that in a divorce case. It would be unethical because the attorney is going to be motivated to get the most possible money that they possibly can so that their fees will be higher. Okay, that's really good when you're doing a car accident, personal injury, medical malpractice case. It's not so good when you're in a divorce case, when potentially that kind of aggression to get the most money out of somebody might destroy somebody's life. Or in criminal cases, it's kind of icky. So completely unethical. And then the fees can never be divided between a lawyer and a paralegal or any other non-lawyer. Two lawyers can split fees on a case, but a lawyer cannot say to the paralegal who works in her firm, hey, I'm going to do this case and I'll give you half. They can't do that. Now, the attorney can, give a raise, but they have to pay them as a regular staff member. They cannot share fees with somebody who's not an attorney. It's not appropriate. Frivolous claims, gifts, and client property. You see all these billboards everywhere and it says, stop frivolous lawsuits. Well, lawyers have an ethical obligation not to file a frivolous claim or any kind of a request of the other party, a discovery request, that they just know is ridiculous. If they do, they can be sanctioned by the court. So frivolous claims pretty much are controlled by the ethical rules and also by the courts themselves. Quite frankly, there's not that many frivolous lawsuits that are filed. A lot of times, frivolous claims are things that are brought by individuals who are bringing those claims themselves without the assistance of an attorney. And I'm not going to lie, there are some attorneys that, they like bringing those frivolous claims. However, there is an ethical rule that says that you cannot do it. If you know a case has no merit, you can't bring that case. Okay, so now a lawyer cannot accept gifts from a client. Now, one of the ways that this sometimes manifests itself is that, a client will say, you've been my lawyer for so long and I really appreciate you. Can you write me up a will? Oh, absolutely, I'll write you a will. Well, in the will, can you please make sure that I'm going to give you $10,000 in my will. So when I die, stop right there. I cannot do that. I cannot prepare a will for a client in which I would receive a bequest or a gift. Okay? Now, if this person is my mother, then I can actually prepare the will. Now, me trying to abide by the utmost ethics rules, I'd probably have one of my friends prepare my mother's will if she was going to leave everything to me. I just don't feel comfortable doing that. I don't want anybody to think that I've coerced my mother into giving me more than what she would give some other member of my family. Also, if a client does give a gift to the lawyer or to the law firm or to the paralegal, that has to be donated to charity. Otherwise, it is considered unethical. So even if they come in, they give you, a gift card to something, you really have to donate that to charity. They come in, they give you a fruit basket. You probably should take the fruit basket down to the local homeless shelter and say, thank you so much. We're really not allowed to accept gifts, but we'll make sure that this goes to somebody who needs it. And that is the ethical rule on accepting gifts from clients. Also, client property, any kind of property that you may be holding for your client, it cannot be mixed in with the firm's account or with any particular lawyer's account. That has to be held in trust, separate from the lawyer's property. So that's why you'll see that, whenever you work in a law firm, that there's trust accounts. Just remember that a lawyer cannot mix his or her property with that of a client. Otherwise, it's unethical. Now, this one's interesting. Reporting professional misconduct. You would think that if you work for an attorney who is doing something wrong, that you should be able to report that, or you're required to report it. But the ABA model rules, which is what you are following for this exam, says that the minimum required conduct is that there is none. There's no blanket rule that requires you to report the professional misconduct of a lawyer. Now, what did I say at the beginning of this? There's nothing stopping you from going above and beyond those minimum requirements. You should report unethical behavior of an attorney that you know of, but you're not required to. So when you're answering that question on the certified paralegal exam, you're going to say, no, there's no requirement that I have to do that. And finally, the unauthorized practice of law. You can go to jail for this, okay? You are not a lawyer. You're not going to be working as one. The lawyers carry all that weight and responsibility on their shoulders. Just remember, these are the things that you cannot do. The unauthorized practice of law is a crime in all 50 states. You cannot accept cases. You can't set fees. You cannot give direct legal advice to clients. You cannot negotiate legal matters on behalf of those clients, and you cannot represent clients in any kind of a court setting. Other than that, you can do just about everything, okay, as long as you follow these 3 guidelines. If your work is properly supervised by a licensed attorney, the attorney must maintain a direct relationship with the client. So it can't be you always dealing with a client who has never met the lawyer. No, it can't happen that way. And also, the supervising attorney has to assume full professional responsibility for the work product. So even though you may be preparing all of the documentation, you did everything for that case, the lawyer has to sign off on it. And if someone's getting sued over it, it's going to be the lawyer, and their malpractice insurance is going to have to cover it. Well, that is today's lecture. If you have any questions, as you know, you can always feel free to contact me at any time. And I wish you a wonderful day.